This is Jonathan Smith versus Amber Ackley. Do I have someone here on behalf of the plaintiff, Jonathan Smith?
Yes, Your Honor, I'm here pro se.
Good afternoon. Do I have someone on behalf of the defendant, Amber Ackley?
Just myself.
Good afternoon, Ms. Ackley. Thank you for
Hello.
being here. All right. Mr. Smith, why was this case filed?
Amber's my ex-wife. We were divorced in March of 2021. I was awarded the subject premises. She's lived there since then as a tenant at will.
Okay.
On the 17th of March, I served her with a notice to vacate. I submitted to the court as Exhibit 2. It's also on the dash of the petition. She was served by the constable the next day, and she's not vacated.
Okay. So, Mr. Smith, you and the defendant were in a landlord-tenant relationship because she was a tenant at will. Did you try her to pay any rent?
No, ma'am. And I'm
Okay.
not seeking rent or court costs or
I still have to take all these, I have to get all the information in because it's part of the order that we fill out. So if there had been rent, it's a part of it. With that, I have to come up with some sort of a determination. So, all right, rent was never a part of the agreement. That's totally fine. And now you said that there came a point though where you gave her a notice to vacate or a notice to terminate.
notice to vacate and demand for possession.
All right. How much time did you give her?
3 days.
And when was that sent?
It was hand delivered on March 17th, 2026.
All right. Good afternoon, Ms. Ackley.
Hello.
Mr. Smith says here that essentially you're a holdover at this stage, that he's asked you to vacate and you have not done so.
That is correct. I do plan to, though.
All right. Well, there's no real dispute about it. It would just be a possession award here. I got to come up with an amount for appeal. Okay, let's think that through. Ms. Ackley, I'm curious. I'll just leave that be. All right. So, state of law in the Texas law for evictions did change, and in January of this year, some new rules came into effect that will impact this case. So I'll give y'all some information. It'd be a judgment for the plaintiff with possession, because Mr. Smith, that's all you're seeking, and there'd never been any agreement between the parties to pay rent. So it's a possession-only award. The monetary portion would be that we would award Mr. Smith, you would be awarded your cost of court. So about $160 or so would be the monetary amount, Ms. Ackley.
Okay.
Now, either party can appeal, as you've heard me say several times. I have to determine an amount for the appeal bond. Because there's never been any rent here, I don't really know what there's nothing to base it upon. Sometimes I'll take into, kind of the average value of the home. I'm curious, are y'all still sharing the unit?
At the moment, I'm living in one of the extra rooms.
Okay, all right. Well, my reason for asking that is Ms. Ackley does not have the entire premises to her own volition, right? She's got her space and then y'all co-share some spots. So that just changes kind of the value of what that is. I'd say here for an appeal bond, I put down $1,500. Okay.
Your Honor, I'll stipulate to a $1 appeal bond. She doesn't have to put anything down if she wants to appeal. And I'll also waive the award of costs.
Can do. All right. The only thing I have to put in then, we'll put down as a $1 appeal. That's easy. You're both being very reasonable. I have no discretion on this. So the state law that changed says even if there had never been rent between the parties, we have to put down $250 as the minimum rent going forward. That does not mean you owe anything, Ms. Ackley, and it doesn't mean you collect it, Mr. Smith. And if she had appealed, she would have to have paid $250 in order for the appeal to go forward, or writ of possession would be issued. That's just a strange thing that changed. It doesn't like it may impact parties here, but when you look at the order will be for possession. It will say that court costs were waived, and then it will say appeal bond of $1, but you will see minimum rent of $250, not because parties ever agreed to pay it, but because that is the state law that requires me to put that down. Okay. All right. Any questions?
No, ma'am.
All right. Very best of luck to all parties then. Everyone is excused. Thank you. Next will be 26574, Lua Owolabi versus Joshua Fall and Madison Nadeau. Do I have someone here on behalf of Owolabi?
Yes, Your Honor.
Good afternoon. Thank you for being here. We have two defendants, so do I have someone first on behalf of Joshua Fall?
Yes.
Good afternoon, sir.
Afternoon.
Do I have someone on behalf of Madison Nadeau?
Yes, Your Honor.
Good afternoon to you as well. All right, so we have all three parties. All right, Ms. Owolabi, tell me why this case was filed.
Yes, Your Honor. Good afternoon. This was filed as an eviction, and originally, the tenants, due to non-payment.
Non-payment. How much is the monthly rent?
Monthly rent, is set at $4,000 a month.
Is there any government assistance?
No.
What months of rent are unpaid?
It was for April.
When was the notice to vacate given?
It was given and posted, on the door of the house, April 2nd.
Inside the house or outside?
Outside.
Was that the only way it was delivered?
And it was also delivered via email.
Okay. Email is the form route, the law is best. All right. You said it was, what day was that?
And that was April 2nd.
April 2nd. All right. Was April the first time the tenants had been late on the rent?
Yes, that was the first time.
Was the notice in April a pay or vacate?
Yes, it was.
All right. Good afternoon, Mr. Fall, Ms. Nadeau.
Noon.
Your landlord says this case is about non-payment. So my first question is it correct that the monthly rent is $4,000?
Yes.
All right. Is this a residential lease or commercial?
Residential.
I'm just curious. All right. And she says that it's the month of April remains unpaid. Is that correct?
Incorrect. So we terminated our lease prematurely due to Lua's failure to comply with Texas Property Code Section 92.052 to remedy and repair the presence of high growth concentrations of toxic mold spanning a significant portion of the property. Both of the species found by the lab were toxic to the ordinary tenant, and we also have a 6-month-old infant. We complied with the property code to provide initial notice on March 9th and subsequent notice on March 22nd, and gave reasonable time for Lua to repair and remedy the condition, 33 days plus time of first notice to when we vacated, and 20 days from the subsequent notice until we vacated. She confirmed that she refused to repair remedy the condition on March 27th. We were current on rent at all times of notices. We notified her on March 30th that we would be vacating prematurely. Our lawyer contacted Lua on April 6th, outlining her violations and to inform her we would be exercising our rights under Texas Property Code Section 92.056F, Subdivision 2, to terminate the lease on 4/11 and deduct rent from the security deposit that she currently holds. And we vacated the property and notified Lua on 4/11.
All right. So Lobby, is that correct? Did the tenants inform you that they were going to be leaving due to an issue with mold?
Yes, that is correct, Your Honor. And that was after the eviction.
No, it may be after you filed the eviction, but it's not. Today's the hearing, right? Ms. Nadeau, what day did you move out?
We moved out on the 4/11 date that we notified her of.
All right. How'd you return the keys?
Left them under the mat, and we emailed her to give her that information and confirmation that we had vacated.
Oh, Lobby, have you gone and checked on your property? Is it vacant?
Yes, Your Honor. So, Your Honor, if I might go ahead and just respond to some of the claims made by the tenant.
It's not necessary, Ms. Owolabi. I'd say is that it's going to be a plaintiff take nothing because you have possession of the property and you still have sufficient rent with security deposit. If you want to pursue them for damages, you might consider a small claims case, but I don't see an eviction here.
Okay, yes,
All right.
that's true, Your Honor. We did, I did respond to change the position of the filing that the tenant were taking possession as for the 14th of this month of the property, and that the filing and the possession is to terminate the tenant terminated the lease, and this is for accelerated rent to the end of the lease, considering that the repair in question was actually repaired and within reasonable time as well.
All right. I appreciate that, but there doesn't seem to be much of a dispute here for me. So it's going to be a plaintiff take nothing because you have possession, but I would set the appeal bond very low. Ms. Ovalabi, if you wish to appeal, it's $500. All right,
Okay,
and there's no rent for you to have to pay because it's your property.
right. And just to confirm, the appeal would not be to appeal in the eviction, but to sue for damages.
No, the appeal would be if you believe I have erred in not awarding you an eviction.
Oh, okay. No,
If
this
you want
is,
to,
so this should have been,
if you want to pursue damages, that is a contract claim and you have 4 years to do that. The eviction is about possession. What you're saying to the court is these people won't give me back my property and I need them to leave so I can start mitigating damages from them not paying. But they have moved out. You do have property back possession. So I couldn't give you a writ of possession because you don't need one.
yes,
If
yeah.
you have monetary damages, you think a list after you account for all the other things between y'all, that's a contract claim that you may very well be able to pursue. A breach of the lease typically allows 4 years for a contract claim.
Thank you, Your Honor.
All right, all parties are excused. Thank y'all, everyone. Good luck.
Okay, Your Honor.
And 26577. This is St. Elmo Mutual Housing Corporation or Sierra Ridge versus Jiren Owens and others. On behalf of
Hi,
Sierra
ma'am.
Ridge.
Yes, ma'am, that would be me, Jasmine McWilliams.
Good afternoon, Ms. McWilliams.
Hello.
And do I have someone here on behalf of the defendant, Jiren Owens?
Yes, ma'am. Yes, Your Honor.
Oh, you're fine, Mr. Owens. I appreciate it. You've been very polite. Don't worry. Don't call me a mean word. We're all good.
No,
Thank you.
ma'am. No.
All right, Ms. McWilliams, why was this case filed?
Yes, this was for failure to pay, rent for
Okay.
March and April. His rent is $999 a month. The 3-day notice was served March the 16th. No rent subsidy. We're asking for past due rent for both March and April, not including late fees, but to include court costs and possession.
Was this a CARES Act property?
No,
All right. Was March the first time the defendant was late?
yes,
Was it a pay or vacate notice?
it was a notice to vacate.
Ms. McWilliams, I'll ask you again. I'm looking at the ledger.
Mhm.
Had the tenant previously been late paying rent?
Yes,
Yes.
December 15th, yes.
Okay. The reason I ask that is there's a new requirement in the law if it's the very first time, but I can see that that is not true. Mr. Owens, this is the first time you weren't able to make it to catch it up, it looks like, per the ledger.
Yes,
Okay, all right,
yes,
then we're all
ma'am.
right. Then we're all doing everything right. Just making sure we're good to go. All right. Good afternoon, Mr. Owens. Thank you for being here. Ms. McWilliams is here representing Sierra Ridge. And so my first question is the monthly rent correct? Is it $9.99?
Yes, Your Honor.
All right. And then March and April, do they remain unpaid?
Yes, Your Honor.
All right. It happens. And with that information, though, the landlord wins the case today. Can I answer any questions for you? This is your chance. I like to highlight numbers, timelines, anything we can do.
I would say, I think I already got the information. Obviously, 5 days is the appeal. 5 days is my max, is the minimum time to vacate. The Travis County, I took that information down. She's already given me, the manager has already given me plenty of information. I think it speaks for itself. I think it's good. Sorry.
No, Mr. Owens, I'm glad. I do repeat myself a lot, but it helps because people got to hear it, and that's the goal, is to make sure it's everyone gets that information. Also, I find, you pay less attention to other people's, and then when it's your case, there's emotions that kick in, and sometimes it makes it hard to really follow along. So I just like to reassure it. All right. Well, the judgment I calculate is it's $9.99 for March, and then for April I got $7.65. So the total amount due will be $17.64. That'll be the judgment amount plus the cost of court.
1764.
$17.64 plus cost. Either
Plus
party can
cost of-
appeal. Because it's only been since March, the appeal bond is equal to the rent, so it's $9.99. And then Mr. Owens, as you said, you have at least 5 more days. Absolutely, that's sacrosanct. Can't take that from you. The
Yes, sir.
landlord can allow you up to 60 days. That is their discretion, though, after that. And then if you want to
Okay.
appeal, that's got to get done within 5. All right.
Okay. Thank you. Thank you, Your Honor.
Absolutely. Very best of luck. Mr. Owens, thank you for coming. Ms. McWilliams, if there's no questions, I thank you both for your patience, and all parties are excused.
I can figure out how to do
26,578. This is Rodrigo and Carmen Castaneda versus Valerie Maldonado. Do I have someone here on behalf of the plaintiffs, Rodrigo and Carmen Castaneda? Good afternoon. We'll need you to unmute. We're going to send you a request. It'll pop up if you hit that button. Good afternoon.
Good afternoon.
Thank you both for being here. I don't see anyone present for the defendant, Ms. Maldonado. It is just us with the court now. All right,
Can
I
I-
do see that she received a return of service. We got that back. So she was served in person by Corporal Gaitan, and that did take place, and she returned that to us. So the defendant did receive service. All right. Ms. Castaneda, Mr. Castaneda, who would like to take the lead and tell me about the case?
I will.
All right, Ms. Castaneda, why was this case filed?
She's very erratic and she doesn't ever hurt us, but she verbalizes us. And it's scary. I shake. I have to call the police all the time because I'm scared for myself and my husband. We're very old and we can't defend ourselves. She tells me she's not going to hurt me, but I can't trust that. So I have to call the police. She right now is in Travis County Correctional Complex. We've had a couple of weeks, I don't want to say nice, but calm here at the house because she's not here. She's in jail. And yeah, it's just disheartening to have to do this.
All right. Ms. Castaneda, let me ask you a few questions then.
Okay.
In the relationship that you have with Ms. Maldonado, do you it sounds like you share a home with her, is that correct?
Yes,
Okay.
she lives in a back bedroom.
All right. And it's not required that you charge rent. Texas does not require that for a lease, but did you charge her rent?
No,
Okay, so there's no rent, that's fine. And did you put in writing a letter to her that says, you scare me, I fear for my life, you need to move out?
no, we just did it with the police and they suggested that we do it this way.
When you say you did it with the police, what does that mean?
Well, when I would talk to them, they would tell me, how to protect myself, just keep calling them, and stuff like that. And yeah, somebody just suggested that maybe we should evict her, and that's what we decided to do.
Okay, Ms. Castaneda, Mr. Castaneda, the first step in the eviction process is that you have to tell the person you want to evict in writing that you want to evict them, and you have to do that
in
before
writing.
you file it with court.
Oh, dang.
So
Yeah.
that's my question is, before you came to court and filed it, did you put a letter in the mail or email it to her that says, I'm scared and you've got to move?
I just told her verbally all the time.
Okay. Ms. Castaneda, Mr. Castaneda, I absolutely empathize with your concerns. It sounds like you're in a situation that's difficult. Unfortunately, if you have not given a written notice to vacate, I'm not able to grant you an eviction because that's a necessary first step. Now, Ms. Castaneda, Mr. Castaneda, nothing says you can't still pursue that.
Okay.
What I would
So what do we do?
I give you that. I can definitely give you that information. I cannot advise you to do anything, but a good first start would be to contact the Travis County Law Library.
Okay,
I'm gonna give you the phone number. All right, I'm not gonna share my screen and get us out of the way. I'm just gonna go ahead and give you the phone number.
okay,
The Travis County Law Library has information that they could assist you with how to file an eviction. You can also, they have what's called an eviction guide and file, and they can ask you some questions. Their phone number is 512. Actually, let me ask, Ms. Castaneda, Mr. Good, do y'all have paper and pen?
yeah, somebody's writing it for me.
Okay, fantastic. It's 512-854-8677. 512-854-8677.
Okay,
Okay. They have free resources there, and there are very specific instructions that they can give you. First step toward an eviction. They even have sample letters of things if you're interested in pursuing it that way. But just in general, the first step is you have to give a written notice to the tenant that you wish them to move, and they need to move by a certain timeline and the reason why. I'm giving you 24 hours or 3 days or 5 days because you didn't pay rent, because you threatened me, because you have an illegal dog in the premises, whatever the violation is. Okay, it sounds like you're alleging a conduct violation.
yes,
That she's threatening you. You give a written notice. You give a timeline. If the tenant does not move by that timeline, then you can come to court and file for the eviction. And that's then what will take place exactly the way you did it. You file the case, the constable would go out and give a notice, and then we have a hearing within 21 days. At that point, we would, if the defendant is here, the defendant could answer. If the defendant does not appear, it may be that you would automatically win by default, and then the eviction judgment would go forward. Okay.
okay. So
Okay.
that means when she gets out, she can come back here?
Ms. Castaneda, I can't actually answer that because I'm not sure of the charges she's facing, what her bond conditions are. I certainly, if you contact legal aid or the law library, you can let them know about the situation that's occurring, that she was arrested, and they may be able to give you information about your rights if indeed you're the victim or the alleged victim of a crime. There might be some other stay away options that are in there. I can't answer that definitively though, because I'm not the lawyer and I have not seen her bond conditions, but there may be something on that as well.
Okay,
Okay.
all right,
All right. Today I'm going to say it's for lack of service. It would be a plaintiff take nothing. You are not at all prevented from trying again. Please do look into the specific ways to give a notice to vacate though. Okay.
okay.
Very best of luck to you both. I hope you are safe. Thank you for coming. Mr. Drake, what's the underlying cause of action?
Yep,
What's the
you nailed
reason?
it, Judge. It's non-payment of rent.
All right. Mr. Seals, is there a dispute that you owe rent?
Yes.
Do you disagree
Yes.
with how much the plaintiff says you owe?
No.
Mr.
Do I
Seals, what do you want
disagree?
the jury trial if you agree that you owe the money?
No, it's a lease violation. The 30-day CARES Act. I believe that I had received a notice to vacate too soon, which led me here too soon. Although I've been working with the legal aid and we were able to get eligibility through ELBWIN to pay the rent that's due. And I have the money now that I have another job to pay my rent on May 1st and going forward.
All right. Tell you what, we'll set this for a jury trial on May 11th. Mr. Seals, Mr. Drake inquired about filing what's known as a motion for summary disposition. And you might also see this called a motion for summary judgment. Only in court do we like to make distinctions and things. Summary judgment is only available in county and district. In justice court, you get a summary disposition, but it's the same thing. What Mr. Drake is saying is that he believes their case that there's no de facto dispute whatsoever. And therefore he would make a motion to win without the need for a jury trial. If he makes such a motion, you'll receive a copy of it, and then you have an opportunity to file an answer that says, no, there is a genuine dispute. And it sounds like the dispute you're alleging would be a dispute over whether the notice to vacate is proper. Is that what you're saying? That you didn't get a proper notice?
That's correct.
All right. So Mr. Drake, there's some information for you about where his position is at. I'm not taking any opinion about whether that's true or I already see a fact question within that. Now, Mr. Drake, Mr. Seals, certainly y'all are welcome to negotiate in the next time. And if y'all come to some other resolution, either before or after we take a look at the motion for summary disposition, or we reach the jury trial on the 11th, that's between parties. Y'all come to anything you want. If you don't, though, there's possibility, Mr. Seals, that we would have before the jury trial on the 11th, a hearing via Zoom like this, which is about whether or not there is a genuine fact dispute arising in this case. And that's what the motion for summary disposition is. All right.
Thank
And
you.
court will reset. I'm gonna reset y'all to a jury trial on May 11th. And certainly if parties file any motions between now and then, court will revisit those. And if we need to have a hearing, we'll schedule those appropriately.
Is it for 9 o'clock AM, Your Honor?
It is.
9 o'clock.
We
Sounds
start
good.
after the jurors arrive at 8:30 and we get them promptly going at 9 o'clock. Usually we have the full category. And Mr. Seals, same thing. I'll just give you information as a pro se party. You can certainly look at any of the legal aid groups that we highlighted, any other legal aid service that you want. Our court did participate in a program with the Austin Young Lawyers Group. We have a series of videos about jury trials. We have those on our website. It may be worth taking a look at those just if you've never seen a jury trial outside of TV, what to expect and how it goes. Because I don't find that ever do they get it right in the media. Okay.
Thank you. Thank you for that.
All right.
Can I ask one question?
Absolutely. I was going to say, do you have any questions before we release parties?
Yes, ma'am. What was that, that term, motion
Motion for summary disposition.
for summary?
Summary disposition.
Okay. Thank you.
Again, you might see it referred to as a motion for summary judgment because they're very similar. It's just a matter of, college, high school, junior high, you got to know what school you're in. But it's what just simply says is that there's no real fact dispute that the thing that this is that this is that this, and there's no other way to outcome it. All right. Any other
Thank you, Your
questions?
Honor.
No, Your Honor, may be excused.
Yeah. All right. All parties are excused. Potentially, we'll see you guys on the 11th. Thank you very
Thank
much.
you, Your Honor. Have a good week.
Thank you.
Thank you.
Thank you both. All right, let me go back to the docket of the day. I'm all the way into May. All right. Now we're going to begin with our final hearings for the afternoon. Our first one on the docket is going to be for J3EV 26560. This is DFC ATX Nichols as an agent for ATX Nichols versus Isaac Atterbury and others on behalf of ATX Nichols.
Nationwide.
Good afternoon, Ms. Carcos. And do I have someone here on behalf of Isaac Atterbury? I don't see anyone present with that name. Stephanie, do you recall if anyone checked in for that one?
No one checked in, Judge.
Okay. Ms. Carcos, tell me about this case and I'll pull up the information about service.
This is failure to pay rent. Rent is $10.65 a month. He owes February through the prorate of April for a total of $2,946 in back rent through today. There's no government subsidy. He's not in the military. 3-day notice to vacate or notice to pay was left inside of his unit on February 6th. This is not a CARES Act property. We're seeking back rent, court costs, and possession.
All right. Only thing I didn't catch was you started the rent. It's 10-6. What was the last number? 1,065. Okay. We did receive back the return of service. Deputy Gamboa effected service to Isaac Atterbury for cost 560. It was attached to the front door and mailed, and we got that back on the 2nd of April. All right, I've got lease ledger, military affidavit. Judgment for the plaintiff, $2,946 in back rent plus cost of court on appeal. February, March. I got a new calculator. I'm just eager to try it out. The appeal bond would be $2,130. That would be twice the rent.
Thank you, Your Honor.
Absolutely. Okay. All parties to that are excused. $26,565. NM South First Holding LLC DBA SoFi at 6311 versus Casey Saldana and others. On behalf of SoFi at 6311.
Nationwide.
You have someone here on behalf of Casey Saldana? Good afternoon. Thank you for being here. Oh, I just finally got it. It's South First. Is that what the SoFi stands for?
Yes.
Man, we got way too carried away with that here in Austin. Okay. Right. I know. Everyone heard the SoCo and we just went with it. All right. Ms. Marcos, tell me why this case was filed.
This is rent. Rent is $2,500 a month. He owes February through the prorate of April for a total of $6,916 and back rent through today. 5-day notice to vacate or notice to pay was mailed on March 5th. There's no government subsidy. We're seeking back rent, court costs, and possession.
Good afternoon, Mr. Saldana.
Hello, afternoon.
Thank you for being here.
Of course.
Ms. Carcos works for a group called Nationwide, and their company was hired by the landlord, SoFi, which also has that long name. So if you have never seen or heard of her, that's not uncommon. But what she came today is she said this case is one related to finances. So not allegations of bad actions in the apartment, but a financial situation.
Right.
So my first question, Mr. Saldana, is the monthly rent correct? Is it $2,500?
It's not 25.
How much is it?
15.
Let's take a look at the lease then. That's a big discrepancy.
Well, it's 14.25, and I think it's another $100, so it's 15.25, I believe.
Oh, I'm sorry, Your Honor. I did. It's $14.25. My apologies. So it's $14.25, and he owes December through April for a total of $6,792. 3-day notice to vacate and notice to pay was given on March 12th, and it was mailed. And there's no government subsidy. My apologies.
Okay. All right. Well, Mr. Saldana, let's take it again. Is the accurate monthly rent $14.25?
Yes, ma'am.
Okay. And has rent remained unpaid in full since December?
Yes, I am aware of that. It's been, I'm aware of it. It's been a rough. I moved to Texas and California. It's just been rough, so sorry.
No, Mr. Saldana, I appreciate that. I have no doubt if you had more money, we would not be here, right? This is not a situation of intent. It's just circumstances have not found us in a good moment.
Yeah,
I appreciate
I hate that we're here. I'm sorry. I apologize to everybody that was involved. So,
Mr. Saldana, I appreciate that. What I'll give you today is a set of numbers, right? And then I'll give you some information about appeal. What I would say is a financial situation is not an immorality thing. It is just an unfortunate thing. Okay. All right. Let me just check again. So it's for December through April, 67.92 is what you got? And
Yes.
that's the proration for April. All right. Would be judgment for the plaintiff, 67.92 as back rent plus cost of court. Either party can appeal. I would set that at twice the rent. To get beyond that is going to become untenable for everyone. So the appeal bond is $28.50. Now, Mr. Saldana, if you wanted to appeal this case, you absolutely can do so. You have 5 days, as could the landlord. When I say there's an appeal bond, and I've chosen to put the appeal bond at twice the rent, so that's $28.50. If you wanted to appeal, but you could not afford the appeal bond, you may qualify to appeal with an affidavit of inability, which means you could essentially appeal for free. However, this is an important caveat. Even if you appealed for free, if you wish to stay in the apartment or in the unit that you're at until a new judge hears the case, you have to pay rent at $14.25. But you pay that to the court instead of your landlord. We would give you very specific instructions about when that's due and how it happens. If you take no action, or if you appeal and don't pay the rent, the landlord can seek a writ of possession, and that is the lawful way in which they would remove you and your belongings from the unit.
Right.
You have at least 5 more days before that can happen. Okay?
Got it.
Can I answer any questions?
No.
All right. Well, Mr. Saldana, very best of luck to you. Thank you for coming. I hope you find yourself in a better situation.
Thank you. Appreciate it.
Thank you. All parties are excused. Next will be 26-571. CHHC Bee Cave as Paseo at Bee Cave versus Thomas Charles Ward and others on behalf of Paseo.
Nationwide.
And do I have someone here on behalf of the defendant, Thomas Charles Ward? Anyone? Look at the room. I see a Thomas Ward as marked in. Mr. Ward,
I'm here. Sorry. I didn't realize I'd gone to mute.
It's an automatic thing. I promise. It's for everyone's benefit that we put you on mute as the default. We've heard some interesting things. So thank you for being here. All right. We have our plaintiff and our defendant. Ms. Carcos, why was this case filed?
This is failure to pay rent. Rent is $15.25 a month. He owes $737 for December, the full amounts for January through March, and then the prorated for April, for a total of $6,481 and back rent through today. There's no government subsidy. A 3-day notice to vacate and notice to pay was mailed on March 5th. We're seeking back rent, court cost, and possession.
All right. Good afternoon, sir. Thank you for being here.
Yeah.
Ms. Carcos works for a group. She was hired by the landlord Paseo. Gia again says this case for this one is also a financial situation. So my first question is the monthly rent amount correct? Is it $1,525?
Yes.
Okay. And then she says there was a partial payment made in December, but that January through April remain unpaid in full. Is that correct?
Yes.
All right, well, Mr. Hart, with that information, the landlord meets the burden to win the case today. Is there any information that you already want to share with me or any questions you immediately know that you'd like to ask? Because this is your opportunity.
Yeah, I mean, it's same as the person before. It's just I got laid off and I asked multiple times if I could do like partial payment because I'm doing DoorDash and Instacart to try and make it meet. And they said no. So, you know, both my parents are older. My dad has Parkinson's. There's been things, but I just couldn't pay in full. The only way I could have done it is partial. And so it just snowballed.
Mr. Hart, I
But
appreciate
Mark,
that.
the manager, has been really, really kind. And in this case, I already have a new place. I haven't told Mark yet. I thought he'd be on the meeting, but I understand about the 5 days, and then that's the minimum. So I'm hoping to be in it by the 3rd. So I was hoping to go to Mark and Paseo and say, look, I have a place. I'm going to be out by the 3rd. Can we just and see what they say? Because they have been more than friendly. You know, we've had a good back and forth this whole time.
Mr. Hart, that seems reasonable. I'll give you some information then. So
Okay.
you absolutely, as you heard me say earlier, you definitely get 5 more days. That is
Okay.
sacrosanct. Nothing can change that, right? The landlord has up to 60 days to seek that writ of possession. So as you just explained,
Okay.
and if you had a good rapport, certainly you can reach out directly to Paseo and let them know, you know, I went to the hearing, I have a place. The landlord, legally, they do not have to allow you that time, right? They can come on day
Sure.
6 and want my writ, but there's nothing that says they must. They have up to 60 days to do so. Even with good cause, they can ask me on like day 65 to get one.
Okay.
Also, just one last thing, or 2 things I'll say. It is not uncommon for the landlord to refuse to accept partial payment. I hear that commonly. And there's
Yeah.
various legal reasons there might be one way or the other. But now that the hearing has been held and it's going to be a judgment for the plaintiff, you may wish to contact either your landlord or any of the legal aid groups that you spoke to and let them know that today you did have the eviction hearing and the landlord did win the case.
Okay.
At least anecdotally, I've heard back from parties that sometimes legal aid jumps them to the top of the line because now you have been evicted. It's not a future possibility, it's a real certainty. Also, that may change what the landlord can legally do per their own terms and conditions. They might just chat with you a different way. Now they have won the case and it's kind of at that stage. All right.
Okay. Okay. I appreciate that very much.
All right. Well, very best of luck to you, sir. Final information I'll say is that the judgment will be 6481. And that is what remained of December, January, February, March, and then 23 days for April. The only extra money added is the cost of court. Either party can appeal. I put the appeal bond at twice the rent, so it's $3,050. And Mr. Hart, as I said to others, if you wish to appeal and can't afford it, you might qualify for an affidavit. If neither party takes any action, judgment is final after 5 days. Okay?
Okay. Yeah, I don't plan any action.
And still my job is to remind people of that. So very
Okay.
best
I
of luck.
appreciate it.
Thank you
Thank
very
you.
much for coming. All parties are excused. 26573. That's also a Paseo at B Caves versus Molina Champion, Oliverto Champion, and Champion and others. Ms. Carcos, you're here for Paseo?
Yes, Your Honor.
All right.
Hey, I really apologize. Can I ask one question real quick and then I'll get off?
All right, go ahead, Mr. Hart.
Sorry about that. Is there a way I can talk to the attorney, or should I just tell my thing to Mark, the manager of the property?
Call Mark the manager. And Ms. Carcos is actually not an attorney. She's an agent and her company represents the landlord. So it's a little bit different, but
Okay.
I know she's just stepped away, but I know that she does not have that authority to negotiate. Contact the on-site management. Ms.
Thank you
Carcos,
very
would you
much.
agree? Contact the on-site management?
Yes, definitely. Contact them.
Okay. Thanks a lot. I appreciate it.
Absolutely. That's a good question. All right. We are now with clause 26573, Paseo versus Champion and Champion. I have Ms. Carcos here on behalf of the plaintiff. Do I have someone first on behalf of Molina Champion?
Yes.
Good afternoon, ma'am. Thank you for being here. And do I have anyone on behalf of Alberto Champion?
Yes, I'm here.
Fantastic. I see you both. All right. Thank you both for being here. Ms. Clarkos, why is this eviction filed, or what was it?
This is failure to pay rent. Rent is $16.96 a month. They owe February through the prorated of April for a total of $4,692 in back rent through today. There's no government subsidy. A 3-day notice to vacate or notice to pay was mailed on March 5th. We're seeking back rent, court costs, and possession.
Good afternoon, Ms. Champion, Mr. Champion. Ms. Clarkos is here representing your landlord, and she's told me this case is a financial situation. Well, my first question, and either one of you can answer, is the monthly rent amount $16.96?
Yes.
Okay. And then is it correct that February, March, and April remain unpaid in full?
Correct.
Okay. Well, with that information, the landlord meets the burden to win the case today. Can I answer any questions? I like to give, timelines, the final numbers, but certainly immediately, if you already know some questions, I'm happy to try to answer them for you.
We've been speaking with Mark, the manager, and we do have the funds to pay the rent. It's just on hold with the bank right now. So we've indicated to him that we'll be paying in just the next few days. We just couldn't meet today's timeline.
Okay.
So I guess my question relates to one of the previous cases. Would we be paying that to the court or to the property?
I'm going to answer that the best I can. I cannot give you legal advice, but I can tell you procedurally what would happen.
Okay.
So, okay.
It might be better if you pay your rent in full, pay it to the property. And if they want, they can, if it's before the 5 days, they can send over to the court that they would like to dismiss the case. And so it's as if this case was dismissed and there was no judgment put in place.
Perfect.
That's exactly right. Ms. Champion, you go and talk to the landlord on site, and the landlord accepts payment in full. Now just be careful here. The landlord can take your money and still want the eviction to be final. But they have the option, and sometimes I absolutely have parties that have worked well together. The landlord can send me something in the next 5 days that says, Judge, we got all our money. Please set aside and vacate the judgment. And we throw it away as though it never happened.
Okay.
And that avoids a final eviction. If that is not something that you can do, or if the landlord is interested in, you still have your right within 5 days to file an appeal. And then if you appeal, that is when we would say you must pay rent to the court.
I see.
Okay. But if you don't need the appeal because y'all work it out some other way, then that would be a private action between you and the landlord.
Thank you for clarifying.
Absolutely. All right.
Okay.
Well, Mr. Champion, did you have questions?
No, I'm pretty sure we've got it figured out and we're going to resolve it. So
Fantastic.
we're all on the same page.
Well, let me give you the numbers for the court judgment. And then again, if y'all come to some agreement, I'm happy to set it aside. The monthly rent is $16.96. The judgment amount today for the plaintiff as back rent would be the $4,692. And if either party wanted to appeal, we would do that at twice the rent. So the appeal bond is $33.92.
Thank you, Your Honor.
All right. Thank you very much. Good luck. I hope that we get the parties work that out.
Thank you.
All right. There's no questions. All parties
Thank
are.
you.
26561. Tanglewood doing business Landmark at Prescott Woods versus Lindsay Hunt and others. On behalf of Landmark,
Stephen Vasquez, Your Honor. I'm also joined with Carla Rodon, who is the Assistant Community Director.
good afternoon to you both. Thank you, Mr. Vasquez and Ms. Rodon.
Hello.
Do I have here on behalf of Lindsay Hunt?
I'm here.
Good afternoon, Ms. Hunt. Thank you for being here. All right, Mr. Vasquez, why was this case filed?
Yes, Your Honor. This is an eviction for non-payment of rent. Monthly rent is $1,008. There is no subsidy. Defendant failed and refused to make rental payments beginning February 2026 and has not paid rent as of today. Total unpaid rent is $2,788.80. That does include a prorated amount for 23 days of this month. A 3-day notice to pay rent or vacate was delivered on March 9th. It was delivered via email pursuant to paragraph 21.1 of the lease. And it was also mailed to the leased premises via first-class mail. In addition to unpaid rent and possession, we're also requesting $1,200 in attorney's fees.
All right. Good afternoon. Good afternoon, Ms. Hunt. Thank you for being here. Mr. Vasquez is here representing the landlord Landmark, and I won't read that long title. You know where you live. They get kind of fun. But what he said is, as I've heard earlier, these cases are a financial matter. So my first question, Ms. Hunt, is the monthly rent amount correct? Is it $1,008?
It is.
Okay. And then do our February, March, and April unpaid in full?
Yes.
All right. Well, Ms. Hunt, with that information, the landlord wins the case. Can I answer questions for you? Is there any information I can provide?
No, it sounds like I need to go through legal aid, just based on what you've said in other cases. So that's my plan, and I do plan to vacate. So.
All right. Ms. Hunt, certainly, if for any questions about, what happens next, or those, legal aid is a wonderful resource. And I'd say if you contact them, contact them within 5 days, it makes more sense than waiting after the appeals deadline, just in case. But you have at least 5 more days to decide what you'd like to do, and that first day is tomorrow. The judgment today would be the $27.88 for back rent, and the attorney's fees for $1,200, and the cost of court. On appeal, the appeal is twice the rent, so the appeal bond will be $2,016. And Ms. Hunt, as I've said, if you can't afford the appeal bond, but you want to do appeal, you might qualify with the affidavit of inability. Certainly, if you come to some other negotiation in the 5 days, landlord can notify me of that. Otherwise, the judgment is due after that. All right. Any questions at all, Ms. Hunt?
Not currently, no.
Thank you for coming. Very, very best of luck to you. I understand these situations are no fun for anyone. All right. Ms. Rodon, thank you for being here. Mr. Vasquez, did you have any other cases today?
No, Your Honor.
All right, then all parties are excused. Thank you all very, very much.
Thank you, Judge. You have a good one.
Take care.